2019, XYZ versus the Republic of Benin. The judge who will read the decision will be Judge Blaise Chikaya. Judge, you have the floor.
Merci, Président.
Thank you, Mr. President. The matter of XYZ versus the Republic of Benin. Mr. Registrar, were the parties invited? Are they present?
Thank you, Mr. President. Mr. President, all the parties were duly informed of the delivery of decisions today. If you allow me, Mr. President, I'll indicate the council that are represented here today. Some are represented online. For application 058-2019, XYZ against Benin, no confirmation from the parties. 009-2020, XYZ against versus Benin, no confirmation. 012 of 2020, Guillaume Soro versus Cote d'Ivoire, no confirmation. 025 of 2020, Bakbo Lurang versus Cote d'Ivoire, no confirmation. 007 of 2023, Democratic Republic of Congo versus Republic of Rwanda. Both parties are represented by counsel. 020 of 2018, Salif Traore versus Republic of Mali. The applicant is represented online. 032 of 2018, Assat Milad versus Tunisia. No confirmation from any of the parties. 001 of 2018, Tembo Hussein versus United Republic of Tanzania. Both parties are represented. 013 of 2018, Emmanuel Yusufu versus Republic of Tanzania. Both parties are represented. 014 of 2018, Ajaye Jogoo versus United Republic of Tanzania. Both parties are represented. And 009 of 2019, Bahatim Tega and another versus United Republic of Tanzania. Both parties are represented. I thank you, Mr. President.
Merci, Monsieur le Greffier.
Thank you very much, Registrar. Judge Chikaya, you may proceed. The matter of XYZ versus the Republic of Benin. Application number 058/2019. The court, composed of Mr. Modibo Sakho, President, Shafika Ben Salah, Vice President, Rafa Ben Ashu, Suzanne Menge, Tijulani Archizumila, Blaise Chikaya, Stella Ayanukam, Imani Diabud, Dumisa B. Nsebeza, Denis Ajaye, Duncan Gaswaga, judges, and Robert Eno, Registrar. Subject of the application, facts of the matter. It emerges from the application that Article 3 of the Order of 22 July 2019 prohibits the issuance of official documents to persons wanted by the respondent states' courts. Some of these official documents are listed under Article 4 of the said order. The applicant avers that the order of 22 July 2019, which in fact targets certain politicians, seriously violates the respondent state's international commitments. On the prayers of the parties, the applicant prays the court to dismiss the respondent state's objection, grant all the requests contained in his written submissions, order the respondent state to make its legislation on wanted persons compliant with the provisions of the African Charter and the relevant provisions of the United Nations. 4. Order the respondent state to pay him the sum of 100 million CFA francs by way of damages for moral prejudice. Orders the respondent state to bear the cost. The respondent state prays the court to find that the applicant brought the case before the court prematurely as he did not exhaust local remedies. Find that local remedies exist, are available, and effective. Declare that the applicant did not exhaust local remedies. Accordingly, declare the application inadmissible. After considering the matter, the court rendered its judgment in the operative part. For these reasons, the court unanimously decided on jurisdiction, declares that it has jurisdiction on admissibility. On admissibility, upholds the objection based on non-exhaustion of local remedies, declares accordingly that the application is inadmissible. On cost, orders that each party shall bear its own cost. Signed, the judges mentioned earlier, done in Arusha, this 26th day of June in the year 2025, in French and English, the French text being authoritative. Thank you, Mr. President. That is the decision. That is the decision of the court. Application number 009/2020 XYZ versus the Republic of Benin. The judgment is rendered by Judge Susan Menge.
Merci, Monsieur le Président.
Thank you, Mr. President. The matter of XYZ versus the Republic of Benin, application number 009/2020, ruling of 26th of June 2025. The court, composed of Modibo Seckou, President, Shafika Ben Saula, Vice President, Rafa Ben Ashu, Susan Menge, Tijulane Al Chizumila, Blaise Chikaya, Stella I. Anukam, Imani D. Abud, Dumisa B. Nsebeza, Denis D. Ajaye, Duncan Gaswaga, all judges, and Robert Eno, registrar. Subject of the application, they are as follows. It emerges from the application that following parliamentary legislative elections of 28 April 2019, protests took place in April and May 2019 within the respondent state's territory. The applicant submits that the security forces clamped down on the demonstrations with their weapons and caused the death of at least 4 persons. He avers that an investigation was subsequently opened in July 2019 before the investigating judge of the 4th Investigating Chamber of the Cotonou First Class for voluntary homicide resulted in the order of 24th October dismissing the case. The applicant further avers that In relation to these facts, the Parliament of the respondent state on 31 October 2019 adopted an amnesty law which was declared to be in compliance with the Constitution by the Constitutional Court in its decision of DCC 19 of 2019. The amnesty law then was promulgated into law by the President of the Republic. According to the applicant, the said law violates the right of victims to judicial protection and to have their case heard. Prayers of the parties are as follows. The applicant prays the court, 1, to declare that it has jurisdiction, 2, dismiss all preliminary objections, 3, declare the application admissible, 4, hold that the respondent state violated the rights of the victims to have their cause to be heard by domestic court guaranteed by Article 7 of the Charter, insofar as it failed to act the due diligence in research. In such investigating and trial of those who were responsible for the atrocities perpetrated across the country during the April 2019 legislative elections, hold that the respondent state violated Articles 4 and 5 of the Charter, hold that the respondent state violated Articles 1 and 7.1 of the Charter by adopting law number 2019 of 7 November 2019, granting amnesty to criminal acts, misdemeanors, or minor offenses committed during the legislative elections of April 2018. Order the annulment of law number 2019-39, granting amnesty for criminal acts, misdemeanors, minor offenses in connection with the 2019 legislative elections. Order the respondent state to set up an independent commission of inquiry to investigate the killings that took place between April and June 2019 throughout the country. Order the respondent state to pay the applicant the sum of 100 million CFA francs in damages for moral prejudice. Report to the court within such time as the court may direct. Order the respondent state to bear the cost. The respondent state, for its part, prays the court to find that the applicant does not allege any concrete situation of human rights violation. Accordingly, declare that the court lacks jurisdiction. Declare that the court has already found that there is no link between the additional application and the initial application. Note that the anonymous applicant is, as of this date, the author of about 10 applications on the merits and requests for provisional measures requested as a matter of urgency since 2019 concerning various situations that he claims to be the cause of human rights violations and for various beneficiaries that he cannot identify personally. Find that the same person cannot at the same time have a real, natural, present, and legitimate interest. Find that the anonymous applicant's multiple applications approach constitutes abuse of court processes. Observe that the anonymous applicant is using the present court as a public forum. Find that the AfCHPR ruled that the request is deemed abusive if an applicant brings multiple moot applications and that it is contrary to the objective of the right to remedy. The respondent continues by saying that the application is abusive and frivolous. Find that the applicant lacks interest in bringing the application. Find that local remedies were not exhausted. Accordingly, declare the application inadmissible. Find that the respondent did not take any measures to limit the protection of the rights guaranteed by the Charter, find that the amnesty law was adopted after investigations, find that an amnesty law does not undermine the protection of patrimonial interests, find that the judicial inquiry did not establish its responsibility for the deaths. Accordingly, dismiss the application. Find the proceedings initiated by the applicant as unfounded and consequently order the applicant to pay the respondent state reparation in the amount of 2 billion CFA francs for all the damages suffered and costs incurred. After deliberations, the court decides as follows. On jurisdiction, declares that it has jurisdiction and dismisses the objection to its jurisdiction. On admissibility, upholds the objection based on non-exhaustion of local remedies. Accordingly, declares the application inadmissible. On cause, decides that each party shall bear its own cost. Signed, the bench which was initially announced, notably President Modibo Seckou, Shafika Ben Salah, Vice President, Rafa Ben Ashu, George, Suzanne Menge, George, Tijulani R. Chizumila, Judge, Blaise Chikaya, George, Stella I. Anukam, George, Imani D. Abud, George, Dumisa B. Nsebeza, George, Dennis D. Ajaye, George, Duncan Gaswaga, George, and Robert Eno, Registrar. Done in Arusha, this 26th day of the month of June, in the year 2025, in French and English, the French text being authoritative. Thank you. And that is the judgment of the court.
Guillaume Kickback Soro and others versus the Republic of Cote d'Ivoire, application number 0112/2020, judgment of 26 June 2025. The court composed of Modibo Seckou, President, Shafika Ben Salah, Vice President, Rafa Ben Ashu, Susan Menge, Tujilane Chizumila, Blaise Chikaya, Stella I. Anokam, Imani D. Dumisa B. Tebesa, Dennis Dominic Ajaye, Duncan Gatswaga, judges, and Robert Eno, registrar. Subject of the application and facts of the matter. The applicants aver that Mr. Guillaume Kickback Soro officially announced his candidature in the October 2020 presidential election. In this political context, some applicants were arrested by the police on instructions of the public prosecutor on the 23 December, between the 31 December 2019. On 23 December 2019, the plane carrying Mr. Guillaume Soro was compelled to land in Accra, Ghana, due to a large deployment of security forces at the Abidjan airport where he was due to land. On the same day, the Abidjan Court of First Instance Public Prosecutor, thereafter referred to as the Abidjan Court of First Instance, announced that a judicial investigation had been opened against Mr. Guillaume Kickback Soro and others for embezzlement of public funds, money laundering, and attempted subversion of state authority. The judicial investigation was based on alleged acts dating back to 2007, when Guillaume Kibafo-Soro was Prime Minister of the respondent state. The applicant averred that an arrest warrant was issued for Mr. Guillaume Kibafo-Soro. They add that some of them were arrested by the police, interrogated without having a lawyer present and without notification of charges, after which they were placed in detention, including in far-flung prisons. They further aver that two of them were declared missing. On 26 December 2019 and 7 February 2020, their lawyers appealed for the annulment of the arrest warrant before the investigative chamber of the Abidjan Court of Appeal. Prayers of the parties. The applicants pray the court to order the respondent state to cease all acts of prosecution brought against the applicants and terminate the criminal proceedings brought against them in violation of the rights guaranteed by the international human rights instruments to which the state of Cote d'Ivoire is a part. Lift the arrest warrant issued against Mr. Guillaume Soro, as well as the detention warrants issued against the other applicants, and seize all proceedings or investigative measures against them. Amend Law number 2018-975 of 27 December 2018 on the Code of Criminal Procedure, in particular Articles 97, 133, and 140, to bring them into line with Articles 2 and 14 of the AfCHPR and Articles 3, 2, 7, and 12 of the African Charter on Human and People's Rights. Pay each applicant the sum of 1 billion CFA francs as full reparation for all damages suffered, and pay all costs in respect of these proceedings. The rule, when a party does not present or abstains within the time frame stated, the court may take a decision in default after having ensured that the party that was defaulted was duly notified of the application and all that the documents concerning the procedure. The court considers that the conditions laid down in Article 63 and decides to make this, decide that it render the judgment in default. Article 3 of the court
concernant l'interprétation et l'application de la charte, du présent protocole et de tous les autres instruments pertinents relatifs aux droits de l'homme et ratifiés par les États
ratified by the states concerned. In contest, to know if the court is has jurisdiction, the court decides that it has jurisdiction to hear this application. Article 6.2 of this decides on the application, taking into account the provisions of Article 6 of the Charter in accordance with Article 51 of its rules. The court considers the admissibility in accordance with Article 60 of the Chart and the protocol and the rule. Having constated the local remedies have been exhausted, and bearing in mind that the conditions of admissibility, the court feels that it is superfluous to
52F of the rules, and the court declares the application inadmissible. After finding that the local remedies have not been exhausted, and considering that admissibility conditions are cumulative, the court does not deem it necessary to consider the last two conditions, and the court declares the application inadmissible. Operative part. On these grounds, the court unanimously, by default of the respondent state, declares that it has jurisdiction, and declares the application inadmissible for non-exhaustion of local remedies. On course, declares that each party shall bear its own course. Signed, all the judges of the bench mentioned, done in Arusha, this 26th day of June in the year of our Lord 2025, in French and English, the French text being authoritative. That is the decision of the court.
Affaire Laurent Gbagbo contre la République de Côte d'Ivoire.
Of Lurang Gbagbo versus Republic of Cote d'Ivoire, application number 025 of 2020, judgment of 26 June 2025. The court composed of Modibo Seckou, President, Shafika Ben Saula, Vice President, Rafa Ben Ashwo, Suzanne Menge, Tijulani Archizumila, Shafika Ben Saula, Blesikaya, Sela Ayanuka, Imani D. Abud, Dumisa N. Nsebeza, Denise D. Ajaye, Duncan Gaswaga, judges, and Robert Eno, registrar. Subject of the matter, facts of the subject of the application, facts of the matter. The applicant averts that having discovered on 4th August 2020 that his name had been removed from the voters register, he submitted on the following day a request for the Independent Electoral Commission and seeking to be reinstated in the said register. On 18 August 2020, the IEC, Independent Electoral Commission, declared his request inadmissible. He appealed against the said decision before the Abidjan Court of First Instance, and on the 25th of August 2020, dismissed this appeal pursuant to Article 4 of Ordinance number 2020-355 of 8 April 2020, amending the Electoral Code. The Abidjan CFI held that the applicant had been sentenced in absentia to 20 years imprisonment by a fine of 10,000 CFA francs by Abidjan Magistrates Court for conspiracy in group armed robbery and embezzlement of public funds. Following this decision confirming his removal from the voters register on account of the above-mentioned conviction and against which, as it emerges from the record, no local remedy was available, the applicant seized this court, given that the situation was in violation of his civil and political rights. Alleged violations. The applicant alleges the violation of the following rights: the right to equality before the law and to equal protection of the law protected under Article 3 of the Charter, the right to fair trial, notably presumption of innocence protected under Article 7 of the Charter, the right to participate freely in the governance of his country under Article 13(1) of the Charter, the right to have access to the public service of his country protected under Article 13 of the Charter, the right to vote and to be elected, protected under Article 25B of the International Covenant on Civil and Political Rights, hereinafter referred to as ICCR. Prayers of the parties. The applicant prays the court to order the respondent state to take all necessary measures to annul Ordinance number 2020/356 of 25 August 2020, issued by the presiding judge of the Abidjan CFI, ruling at instance of electoral matters and its legal effects, with the effect of lifting all measures restricting his civil and political rights, expunge from his criminal record, or if necessary, refrain from mentioning therein the criminal conviction by default number 5200 of 2019 of 29 October 2019, which is not yet final. On the default of the respondent state, there's a rule which provides that where a state fails to appear, the court may, at the behest of the other party, render a judgment in default after ensuring that the application and all the other relevant documents were served on the parties. The court, therefore, renders this judgment in default. On jurisdiction, the court notes that Article 3 of the protocol provides that the court has jurisdiction to hear all cases and all defense brought before it concerning the interpretation and application of the Charter, this protocol, and any other relevant human rights instrument ratified by the state concerned. In case of any challenge as to whether the court has jurisdiction or not, the court shall decide. The court, therefore, considers that it has jurisdiction to hear this application. As regards admissibility, Article 6 of the protocol provides that the court shall deal with admissibility of the applications under Article 6 of the Charter. Pursuant to Article to Rule 50 of its rules, the court shall consider, therefore, the application based on Article 56 of the Charter and 6.2 of the Protocol. The court therefore considers that the application meets all the conditions of admissibility under Rule 50 of the Rules of Court and therefore declares that the application is admissible. On course, the court decides that the applicant will bear his own course, operative part. On these grounds, the court unanimously, by default, declares that it has jurisdiction on admissibility, declares the application admissible, and on the merits says that the applicant, the rights were not violated by the respondent state, and under the equal protection of the right, and read jointly with Article 56 of the AfCHPR, the respondent state did not violate the right to presumption of innocence under Article 7 of the Charter, and that the respondent state did not violate his right to participate in the governance of his country under Article 13.1 of the Charter, and that the respondent state did not violate the right for him to participate in the governance of his country under Article 13.2 of the Charter, and that the respondent state did not violate his right to be protected under Article 56 of the AfCHPR. The court dismisses the applicant's prayer to stay the execution of order number 3505 of 2020 of the 25th August of 2022 by the Abidjan CFI, confirming the removal of the applicant's name from the voters' list, dismisses the request for vacation of the criminal conviction and the request for the stay of execution of the same sentence. On course, holds that the applicant shall bear his own cause. Signed, Modibo Seckou, President; Shafika Ben Salah, Vice President; Rafa Benashu, George; Susan Menge, George; Tijulani R. Chizumila, George; Blaise Chikaya, George; Stella Ayanukam, George; Imani D. Abud, George; Dumisa B. Nsebesa, George; Denis D. Ajaye, George; Duncan Gaswaga, George; and Robert Eno, Registrar. Done at Arusha, this 26th day of the month of June, in the year 2025 in English and French, the French text being authoritative. That is the decision of the court.
Requête numéro 007
Petition number 007-2023, Republic of Democratic Republic of Congo versus Republic of Rwanda. The decision will be read by Honorable Judge Rafa Benashu. We'd like to invite the representatives of the parties to appear. Honorable Judge Dean, the floor is yours.
Vous avez la parole sur la question.
Honorable Président, honorable juge, je suis
Honorable
maître
President,
Yvonne
honorable
Bacham,
judge,
avocat et
Council
agent et
Major
avocat conseil de la
agent
République démocratique du
and
Congo.
Council of
Je
the
vous en remercie.
Democratic Republic of Congo. Thank you very much.
Monsieur le greffier,
The registrar,
est-ce que le représentant de l'État,
the representative of the state of the Republic, is he online? Are they online
présent dans la salle?
or present in the hall?
Humble President, they did confirm that they'll be participating. But maybe they are online or I'm not sure.
Yes, we are online.
Merci. La décision sera lue par l'honorable juge doyen, le juge Rafa Benashu.
Judgment will be read by Honorable Judge Dean, Honorable Ben Asher.
Merci, Monsieur le
Thank
Président.
you, Mr. President.
Affaire
The
République
matter
démocratique du
of
Congo
Democratic Republic of Congo
contre République
versus
du
Republic
Rwanda,
of Rwanda,
requête numéro
application number
007/2023,
007/2023,
arrêt sur la
ruling
compétence
on
et la
jurisdiction and
recevabilité.
admissibility.
La Cour,
The court,
composée
composed of
de
Modibo Seckou, President, Shafika Ben Salah, Vice President,
Rafa Benashu,
Rafa Benashu,
Suzanne Menge,
Susan Menge,
Tidjani
Tujilani,
Chizumila,
Chuzimila, Blaise Chikaya, Stella Anukam, Imani Aboud, Dumisa Tibesa, Denis Ajaye, and Duncan Gaswaga, judges, and Robert Eno, registrar. After deliberation, they renders the following judgment in the subject of the application, facts of the matter. The applicant state alleges that since November 2021, in the North Kivu region, which is in the east of its territory, a conflict has raged between its forces, Force Armée de la République démocratique du Congo, after referred to as the FRDS, and a coalition comprising the March 23 rebel movement, hereinafter referred to as the M23, and the RDF, herein referred to as the Armed Coalition. The applicant state affirms that since 2022, hostilities have intensified due to attacks carried out by the Armed Coalition against FRDC positions and those of the United Nations Peacekeeping Mission, MONUSCO. It adverts that as at the time of filing this application, the Armed Coalition had seized several localities in North Kivu province. According to the applicant state, the atrocities perpetrated by the Armed Coalition have resulted in the death of several people, internal displacement, and the destruction of schools, public infrastructure, and private property. According to the applicant state, the conflict is a consequence of the wars of aggression firstly waged against it by the respondent state from 1998 to 2002 by the respondent state, and from 2008 to 2009, and secondly by the respondent state together with a rebel group called the National Congress for the Defense of the People, the CNDP, and finally by the Armed Coalition from 2012 to 2013. The applicant state avers in this regard that in the context of the first conflict mentioned in the preceding paragraph, the African Commission on Human and People's Rights found that the respondent state had violated the provisions of the Charter and recommended adequate reparation for the victims. Finally, the applicant state emphasizes that the respondent state has refused to prosecute or extradite persons against whom Congolese courts issued arrest warrants for international crimes following the wars of aggression, in particular, Mr. Lurang, former leader of the CNDP, as well as leaders of the M23. Prayers of the parties. The applicant state prays the court to first declare that it has jurisdiction and that the application is admissible, to declare that the respondent state violated Articles 1, 4, 5, 6, 7, 1A, 14, 16, 17, 18, 1, 22, 23, and 24 of the Charter, Articles 3, 1, and 2, 4, 10, 11, 12, 15, 18, 1, and 19C of the Protocol on Women's Rights, Articles 5, 1, and 11, 1 of the African Charter of the Rights of the Welfare of the Child, Articles 2, 1, 6, 1, 7, 8, 9, 1, 10, 1, and 12, 1 of the International Pact on the Civil and Political Rights, and Articles 12, 1 and 13, 1 of the International Pact on Economic, Social, and Cultural Rights. Thirdly, declare that the respondent state has an obligation to withdraw all its troops from its territory and to cease forthwith all forms of support to the M23 so as to end the human rights violations for which the court has found the respondent responsible. 4. Declare that the respondent state has an obligation towards the Democratic Republic of the Congo and its people, victims of the said violations, to provide adequate reparation for all the harm resulting from violations. 5. Declare that the issue of reparation due the Democratic Republic of Congo and its people victims of the human rights violations perpetrated by the respondent state will be settled by the court and reserve further proceedings to this end in accordance with the provisions of Article 27.1 of the Protocol and Rules 4, 40, and 69.3 of the Rules of Court taken together. 6. Order the respondent state to reimburse the Democratic Republic of Congo all costs incurred in bringing and supporting this case before the court. For its part, the respondent state praised the court to declare that it lacks jurisdiction and to hear the case, or in the alternative, declare the application inadmissible. On the jurisdiction of the court observes that the respondent state raises objections to its jurisdiction. The court will therefore address the said objections before examining the other aspects of its jurisdiction, if necessary. As regards objections to the jurisdiction of the court, the respondent raises objections to the material and territorial jurisdiction of the court, which the court will examine successfully. First, on objections to material jurisdiction, the respondent state raises 3 objections to the court's material jurisdiction, namely the absence of a dispute, the fact that the applicant state invokes texts that are not human rights instruments, and that the applicant state invokes human rights instruments that Rwanda has not ratified. On the objection to material jurisdiction based on the absence of a dispute, the court observes that in this case, the issue for determination is whether the terms cases and disputes referred to in Article 3 of the protocol should be understood in accordance with the jurisprudence of the International Court of Justice as developed under Article 38 of the statute of the ICJ, which provides that its function is to decide such disputes and submitted to it. It should be noted from the outset that although it is true that the court may draw inspiration from international jurisprudence, including that of the ICJ, the European Court of Human Rights, and the Inter-American Court of Human Rights, it nonetheless applies its own procedural text, namely its protocol and its rules of court. And the court is not bound by the statutes and procedural rules applicable before any of the earlier mentioned courts. The court emphasizes that in line with its jurisprudence, it does not limit itself to the definitions of the terms, cases, and disputes taken separately, but contextually interprets Article 3 in accordance with the object and purpose of the protocol. The words, and I quote, all cases and disputes submitted to it cover without distinction all applications submitted to the court to determine the responsibility of the state concerned relating to alleged human rights violations and where necessary to order appropriate reparations. As the court has constantly held, Article 3.1 of the protocol gives it jurisdiction whenever an applicant alleges violations of human rights protected by the Charter or by any other human rights instruments to which the state concerned is a party. This applies regardless of whether an application is filed by individuals, the Commission, or state. The court's jurisdiction to hear a case is therefore not subject to any formal requirement to prove the prior existence of a dispute before the filing of the application. In the light of the foregoing, the court dismisses the respondent's state objection that it lacks jurisdiction to hear this case due to the absence of a dispute. As regards objection to material jurisdiction on the grounds that certain instruments invoked by the applicant state are not human rights instruments. The court confirms that whether a treaty is termed as a human rights instrument is relevant only when, in a given case, the rights alleged to have been violated are protected solely by that treaty. On the contrary, there is no need for such a designation when the rights alleged to have been violated are protected by other treaties, which are manifestly and universally recognized as human rights instruments. The court recalls that in its application, the applicant state accuses that the respondent state of being directly responsible for the violations of human rights perpetrated by armed forces in disregard of the relevant provisions of the Charter. So it follows that the court refers to the question doesn't have any impact on the decision of the court, and if the right that it alleges is protected by a treaty ratified by the state concerned, the court notes, among others, that in its statement of alleged violations, the applicant state did not refer to the Charter of the United Nations, the Constitutive Act of the AU, the Great Lakes Pact, or the PSC Framework Agreement. However, it alleged the violation of paragraph 6 of the Pretoria Declaration concerning the right to education and the right to property, rights which are all protected by the Charter. In any event, it is clear from the application that all the rights alleged to have been violated are protected by the Charter, the Protocol to the African Charter on the Rights of Women, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, all of which are incontestably human rights instruments. The above instruments are sufficient to establish the court's jurisdiction without it being necessary to determine whether the Pretoria Declaration, the Great Lakes Pact, the Constitutive Act, and the United Nations Charter are human rights protection instruments. Notwithstanding the foregoing, the court considers that there is nothing to prevent it from examining the question whether the Charter of the United Nations, the Constitutive Act of the African Union, the Great Lakes Pact, and the PSC Framework Agreement are instruments for the protection of human rights. And the court underscores that to qualify as a human rights instrument within the meaning of the Article 3, the court can draw inspiration in accordance with Article 60 of the Charter. Concerning the Great Lakes Pact, the court points out that it prescribes in some provisions obligations of member states, and the articles of the Great Lakes Pact mentioned in the previous packet are provisions of protection of human rights. In any case, it emerges from the application that all the allegations of the respondent state are protected by the Charter, the PIDEC, the African Charter on the Rights and Welfare of the Child, and the Protocol on the Rights of the Women, which are all instruments of human rights protection ratified by the respondent state, which justifies that the objection of jurisdiction cannot be upheld. As regards the exception of material objection drawn from the non-ratification by the infringing state, the instrument of protection of human rights mentioned by the applicant state. The court recalls that it is the Pretoria Declaration and the Framework Agreement of Addis Ababa are not human rights instruments in the meaning of Article 3(1) of the protocol, the fact that since they are not treaties, hence this objection has to be dismissed based on the territorial objection. The court recalls that while it is true that in all applications that has been seized, by persons and NGOs with overt taxes before the Commission, the facts must have taken place on the territory of the respondent state. It has therefore consistently held that it has territorial jurisdiction in the light of this fact. In the instant application, the court has judged that it has territorial jurisdiction to hear the case. However, the court has to consider if it can, in certain circumstances, exercise its territorial jurisdiction when the alleged violations occurred outside the territory of the respondent state. The court notes in this fact that the state's jurisdiction may be outside its territory, since in accordance with a well-established rule of international law of Costa America, the conduct of any organ of a state must be regarded as the act of that state, whether that conduct took place within or outside its territory. In this regard, the court observes that this legal reality is reinforced by the fact that international human rights instruments are applicable to acts of a state acting in the exercise of its jurisdiction outside its own territory. In light of the foregoing, the court feels that it has territorial jurisdiction to hear this application. In the other aspects of the jurisdiction, personal and temporary jurisdiction, the court deems it has jurisdiction to hear this application. As regards administratively, the court knows that the respondent state raises two objections to the admissibility of the application. Firstly, based on the conditions not provided for in the chart, and secondly, on the basis of conditions listed in the charter. As regards objections to admissibility based on conditions not provided for in the chart, the respondent state argues that application should be declared inadmissible on the grounds that the applicant state failed to comply with the preliminary non-judicial procedures required by the first, the Great Lakes Pact, second, and the Constitutional Act, and the third, that the application is an abuse of process.
De règlement des différends entre États parties. Tandis qu'à travers le deuxième,
the second, these states agree to submit to the court all disputes on the interpretation and application of all or part of the Great Lakes Pact. The court underscores that as regards in matters of procedure, it applies the charter, the protocol, and its rules, and if necessary, well-established general principles of procedure. This principle remains the same, irrespective of the instruments cited in support of the applicant's allegations. It does not escape the court's notice that the African Court of Justice, to which the parties agreed to submit their disputes concerning the interpretation or application of the Great Lakes Pact, or is different from this court, not to mention that it has not been authorized by the AU. So the court therefore finds that the rules of procedure outlined under the Great Lakes Pact are not applicable before it. Secondly, the second objection is based on alleged non-compliance with the preliminary non-judicial procedure required by the Constitutional Act. This objection is also dismissed. With regard to the abuse of process, the court dismisses this objection of inadmissibility. As regards the conditions of admissibility provided for in the charter, the respondent state raises objections to the admissibility of the application on the grounds that the application is incompatible with the Constitutional Act and based on news disseminated by the mass media. and that the application was not filed after exhaustion of domestic remedies, and that concerns cases that were settled in compliance with the principles of the Charter of United Nations. The four objections were dismissed, each after reasoning of the court. On these grounds, and as regards and based on all these demonstration, the court unanimously on jurisdiction dismisses the objections to the derivation and declares itself because it has jurisdiction to hear these application on the admissibility, declares the application admissible, reserves its decision on merits, reparations, and costs, and the state a deadline of 90 days to the respondent state when the application is notified to it to submit it, lays a deadline of the referent applicant state of 45 days to submit its reply signed. The judges that were mentioned at the beginning of this draft, done in Arusha, this 26th day of June of 2025, in English and French, both texts being equally authoritative. Thank you very much, Mr. President.
Quelle est la décision de la Cour?
Of the court.
La requête numéro 020-2018, Salif Traore et
Is Salif Traore and Seckou Omar Koulibaly. It will be delivered by the Vice President of the court. Thank you. Thank you, Mr. President. So, in the matter of application number 020/2018, Salif Traore and Seckou Omar Koulibaly versus the Republic of Mali, Judge Chikaya will have the honor to render this judgment. Are there any representatives present or online? Dr. Eno, is either of the parties present or represented online? Is there someone online?
Oui, Monsieur Boubacar Koulibaly doit être en ligne.
Mr. Boubacar Koulibaly is supposed to be online, but he's not online. Judge Chikaya, you may proceed. The matter of Salif Traore and Seckou Omar Koulibaly versus the Republic of Mali. Application number 020/2018. On the composition of the court, there's Chafika Ben Salah, Vice President, Rafa Ben Ashu, Suzanne Menge, Tijulane Aro Chizumila, Blaise Chikaya, Stella Anukam, Imani Aboud, Dumisa Nsebesa, Denis Ajaye, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 9.2 of the Rules of Court, Judge Modibo Sakho, President of the Court, and a national of Mali, did not hear the application. Subject of the application, facts of the matter, it emerges from the application that on 16 December 2002, the President of the Republic of the respondent state promulgated into law number 02/056 on the status of officers of the National Police Force. On the basis of this law, the President of the Republic signed the decree of 6 February 2006, whose Articles 46 and subsequent articles set out the transitional provisions applicable to the training of police officers. Owing to the urgent need to expand the officers' corps of the national police, the respondent states authorities opted for recruitment through internal promotion within the police force. Pursuant to the decree of 6 February 2006, the Minister of Internal Security selected police officers with higher qualifications based on very specific criteria, in particular, 15 years length of service in the police force and a qualification obtained before the 31st of July 2008. Following this selection, officers who met the said criteria were identified and appointed as trainee police inspectors and superintendents. It also emerges from the application that the aforementioned law 02056 of 2 December 2002 was subsequently repealed by law number 10034 of 12 July 2010 on the status of officers of the National Police. On the 13th of July 2014, the applicants wrote to the Minister of Internal Security regarding their situation, but did not receive any response. On 12 November 2014, the applicants filed a petition before the administrative section of the Supreme Court against the Minister of Internal Security, seeking regularization of the administrative situation on the grounds that other police officers in the same legal situation as themselves had been appointed as trainee police inspectors and superintendents in order to continue their training at the police academy. The applicants aver that the act of treating some police officers differently as compared to others constitutes a violation of the principle of equal treatment of citizens in access to public services. By judgment of 7 December 2025, the administrative section of the Supreme Court issued an order regularizing the applicant's administrative situation. On 27 January 2016, the General Directorate of State Litigation appealed the aforementioned decision, requesting the Supreme Court to rule in favor of the Ministry of Internal Security. In its appeal, the DGSL challenged the Supreme Court's decision on the basis of Article 3/71 of the Organic Law, published on the 16th of December 1996 on the organization and functioning of the Supreme Court. According to the DGSL, the Supreme Court erred by misapplying or misinterpreting the law. On the 4th of August 2016, the administrative section of the Supreme Court dismissed the appeal. On 8 June 2017, the DGSL filed an application for review in accordance with Article 256 of Law for 26 September 2016 on the Organic Law regulating the operations of the Supreme Court and the procedures followed before it. The DGSL reiterated its claims based on the Supreme Court's new jurisprudence in the matter of Koulibaly and others, judgment number 186 of 17 April 2016. According to this new ruling, it is a general principle of civil service law that a civil servant cannot claim a right illegally granted to another. Anyone claiming to hold a right must be able to justify it. By judgment number 412 of 10 August 2017, the Supreme Court annulled the two decisions previously handed down by the administrative section and dismissed the applicant's appeal for lack of merit. On the prayers of the parties, the applicant prays the court to declare the application admissible, find that the application is well-founded, find that the respondent state violated the right to equal treatment of persons in the same situation, find that the respondent state violated their right to non-discrimination by regularizing the status of certain police officers while leaving the others to fend for themselves, which occasioned a denial of justice. Find that the respondent state is responsible for the violations, declare that by these decisions, the respondent state violated the applicant's procedural rights, and order the respondent state to pay each of the applicants the sum of 250 million CFA francs by way of reparations. The respondent state, for its part, praised the court to rule on the admissibility of the application, and that the application should be dismissed, and dismiss the application as unfounded and order the applicants to bear the cost. I'll move on to the operative part of the judgment, which the court renders on this judgment. For these reasons, the court unanimously on jurisdiction declares that it has jurisdiction, on admissibility declares the application admissible, and on merits holds that the respondent state did not violate the applicant's rights of equality before the law and non-discrimination protected by Article 3.1 of the Charter, as read jointly with Article 26 of the AfCHPR. The court holds that the respondent state did not violate the applicant's right to have their cause heard, protected by Article 7.1a of the Charter. On reparations, the court dismisses the applicant's prayers for reparations, and on costs, orders that each party shall bear its own costs. Signed, the judgment is signed by the judges of the bench whose names were mentioned earlier, done in Arusha this 26th day of the month of June in the year 2025 in Arabic, English, and French, the French text being authoritative. That is the decision of the court, Madam Vice President. Thank you. That is the decision of the court.
Merci, Madame la Vice-Présidente.
Thank you, Madam Vice President. Thank you, Judge Kaya. The next application, the next judgment is application number 032/2018, Assat Milad versus the Republic of Tunisia. The judgment will be read by the Honorable Vice President. We call on Judge Rafa to recuse himself. Madam Vice President, you have the floor.
Merci, Monsieur le Président.
To Mr. President.
The matter of Assat Milad versus the Republic of Tunisia, application number 032 of 2018. This is decision of 26 June 2025.
Getting anything?
The court composed of Modibo Sako, President.
I'm not getting it.
Benstola, Vice President. Susan Mange.
I'm not getting it. They're working into. You're right. They're working into English.
Okay. B. Nsibeza. Dennis D. Ajaye. Duncan Gaswaga. These are judges, and Robert Eno, registrar.
On me dit qu'il n'y a pas de traduction aussi. Si vous l'avez, OK. طبقا للمادة 22 من البروتوكول
In
الميثاق
accordance with
الإفريقي
Article
لحقوق الإنسان
22 of
والشعوب
the Protocol to
بشأن
the
إنشاء
African Charter
محكمة
on
إفريقية
Human and
لحقوق
People's
الإنسان
Rights
والشعوب
and the
يشار
establishment of an
إليه فيما
African
بعد
Court on
البروتوكول
Humans and People's Rights
والمادة
here and
9
referred to as the
فقرة
Protocol
2 من النظام الداخلي
and Rule
للمحكمة
9.2
يشار
of the Rules
إليها
of
فيما
Court
بعد
here and
بالنظام
after referred
الداخلي
to
تنحى
as
القاضي
the
رافع بن
rules.
عاشور التونسي
Justice
الجنسية
Rafa Ben
عن
Ashur,
نظر
Judge of
هذه
the Court and
القضية.
National of Tunisia did not hear the application.
عن الوقائع يظهر من
Subject
العريضة
of the
أن
application
المدعي
fact.
كان مساهما في
It
الشركة
emerges from the
التونسية
application
المدني
that the applicant was a
la
shareholder
société tunisienne des
in the
structures métalliques
Société
يشار إليها فيما بعد
Société
بميلاد
Tunisienne des
مثال
Structures Métalliques
والتي
referred to
عرضت
as the
عددا
Metal
من
Milad,
العقارات التابعة
which
لها للبيع في
at
المزاد العلني
auction
بتاريخ
of a
15
number of these
أغسطس
properties on
2008
15 August
لصالح
2008
الشركة التونسية
to the
البنك
Société
Société
Tunisienne de
Tunisienne de
Banque.
Banque. في 15 أغسطس
On
2008 شارك
15th
المدعي مع
August
شركة
2008,
عقارية
the
الشارع
applicant,
يشار
together with
إليها
the
فيما
real
بعد
estate
بعقارية
company
الشارع
Ajaye Share,
والتي هي فرع من فروع الشركة
which is
التونسية
a
للبنك
subsidiary
في
of the
مزاد
Société
علني
Tunisienne de Banque,
لبيع قطعة
took
أرض
part in the auction
وخلال
of a
جلسة
plot of
البيع
land.
بالمزاد رأس
During the
العقار
auction,
البالغ
the
مساحته
plot
60,000
measuring
متر
60,000
مربع على
square
شركة
meters
عقارية
was
الشارع.
sold to the
زعم المدعي
AREC.
بأن
The applicant
مزايدته كثمن
assumes
للعقار
that his bid
البالغ
for
مساحته 60,000 متر
60,000 square
مربع
meters plot
كانت
was
تزيد
higher
السدس
than
عما
that of
عرضته
the
الشركة عقارية الشارع.
Ajaye Share by more than one-sixth. The applicant also submit that in accordance with Article 442 of the Tunisian Code of Civil and Commercial Procedures, promulgated by law number 130 of 5 October 1959, and amended by law number 2010-66 of 5 July 2010, the property in question was listed for re-auctioning. During the bidding session for the re-auctioning of the property, the applicant challenged the participation of the AfCHPR company before the District Court of Belarus, alleging that the said company did not meet the conditions stipulated in Article 444 of the Tunisian Civil and Commercial Procedures Law. The objection was, however, dismissed on the 15th of October 2008, and the property was sold to AfCHPR. Subsequently, ownership of the property was formally transferred to the AREC by decision number 2028 of 15 October 2008, issued by the Property Sales Division. The applicant challenged the decision before the Belarus Court of First Instance, claiming that the AfCHPR company participation in the auction was illegal. On 3rd of November 2010, the Court of First Instance rendered judgment number 22538 dismissing the applicant's case. The applicant then appealed against the judgment of the Court of First Instance number 22538 before the Tunisian Court of Appeals, which by judgment number 31528. The applicant subsequently appealed the said decision before the Cassation Court, which issued its judgment on 30 April, allowing the applicant's appeal and referred the matter back before the reconstituted bench of the Court of Appeal. The Court of Appeal reconsidered the case, and by judgment of 8 April 2016, reversed its earlier judgment of 12 March 2013, as well as the judgment of 15 October 2008, rendered by the Court of First Instance. The AfCHPR company then lodged a cassation appeal against the court on 8th of April 2017 before and issued that decision on the 1st of December 2017. That cassation court quashed the contested judgment without referring the matter back to the Court of Appeal. With regard to the prayers of the parties, the applicant praised the court the following: declared that his right to fair trial was violated owing to the decision taken by the institutions of the respondent state's judiciary, ordered the respondent state to retain the property in question to the applicant, value it at the closing price of the first auction, order the respondent state to pay him a reparation of at least 31 million euros for damages suffered. In the event that it is impossible to retain the property, to compensate him with at least 50 million euros for the damages suffered. Order all necessary measures with a view to reach amicable settlement without respondent state before reconsideration of the case. The respondent state praised the court to declare the application inadmissible and consequently dismiss it. After considering the objections raised by the respondent state, the court decided that it has jurisdiction, material jurisdiction, personal jurisdiction, and temporal jurisdiction, and territorial jurisdiction, and the merits. And after considering the applicant's allegations and prayers, the court decided as follows, and here is the operative part. For these reasons, the court unanimously, on the amicable settlement, dismisses the applicant's request for amicable settlement. On jurisdiction, dismisses the objections to jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objections to admissibility of the application, declares the application admissible. On merits, holds the respondent state did not violate the applicant's right to property protected under Article 14 of the Charter, holds that the respondent state violated the applicant's right to fair trial protected under Article 7(1)(a) of the Charter, as read jointly with Article 14(1) of the AfCHPR regarding the failure of the domestic courts to deliver their decisions in open court. On reparations, dismisses the prayer for reparation of the material prejudice, grants the applicant's prayers for reparation of the moral prejudice suffered, and awards him the sum of 600 Tunisian dinars. Order the respondent state to publish this judgment within after notification on the website of the judiciary, and to make it available for 1 year after the decision. Order the respondent state to report to this court within 6 months signed by the registrar done at Arusha this 26th day of June in the year 2025 in Arabic, English, and French, the Arabic text being authoritative.
Telle est la décision de la Cour.
This is the decision, the judgment of the court.
Nous invitons le juge doyen, honorable juge Benachou.
Invite the judge, Honorable Judge Benachou, to return to his seat.
Requête numéro 001-2018. Tembo Hussein.
Application number 001 of 2018 in the matter of Tembo Hussein versus United Republic of Tanzania. The registrar and representatives of the respondent state in the
No,
no, the applicant is not in this chamber.
Très bien. Le jugement doit être lu par l'honorable.
Very well. The judgment will be read by Honorable Chizumila, but first of all, we are going to ask Honorable Judge Emmanuel Aboud, Tanzanian national, to please recuse herself.
Honorable Juge Chizumila, vous avez la parole, s'il vous plaît.
Judge Chizumila, you have the floor, please.
Thank you, Honorable President. This is the matter of Tembo Hussein versus United Republic of Tanzania, application number 001 of 2018, judgment of today. The court, composed of Modibo Sako, President, Chafika Ben Saula, Vice President, Rafa Ben Ashur, Susan Menge, Tujilane R. Chizumila, Blaise Chikaya, Stella I. Anukam, Dumisa Bin Sebeza, Dennis D. Ajaye, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, and Rule 9.2 of the Rules of Court, Justice Imani D. Aboud, Judge of the Court, and a national of Tanzania, did not hear this application. Facts of the matter. It emerges from this record that the applicant was arrested on 27 September 2006 at Masumbwe village within Kahama district in Shinyanga region and charged with the murder of one Angelina Hungwe by inflicting on her multiple cuts with a machete. He was convicted of murder and sentenced to death by hanging by the High Court sitting at Tabora on 11 October 2013. The applicant filed an appeal before the Court of Appeal sitting at Tabora, which was dismissed on 15 March 2014. An application for review of the Court of Appeal's decision filed by the applicant before the Court of Appeal was dismissed on 7 August 2017. Prayers of the parties. The applicant prays the court to 1, restore justice where it was overlooked and quash both the conviction and the sentence imposed on him and set him at liberty. 2, grant any other order that it may deem fit and just to grant in the circumstances of the complainant. The respondent state prays the court for the orders that 1, the Honorable Court is not vested with jurisdiction criminal jurisdiction to adjudicate the application. 2, the application has not met the admissibility requirements provided in Article 56(6) of the Charter, read together with Rule 52E of the Rules of the Court of 2020. The application be declared inadmissible. 4, the respondent state has not violated the applicant's rights provided for in Article 3, 1, and 2 of the Charter. And finally, 5, the application be dismissed in its entirety with costs. I now move to the operative part. For the reasons that have been discussed in the judgment, the court unanimously on jurisdiction, 1, dismisses the objection to its jurisdiction. 2, declares that it has jurisdiction. On admissibility, 3, dismisses the objection to the admissibility of the application and declares that the application is admissible. On merits, it holds that the respondent state did not violate the applicant's right to be tried by an impartial court or tribunal protected under Article 7(1)(d) of the Charter with regard to the allegation of bias of the assessors and the allegation that they cross-examined the witnesses. Holds that the respondent state did not violate the applicant's right to equality before the law and to equal protection of the law under Article 3, 1, and 2 of the Charter. By a majority of 8 for and 2 against, holds that the respondent state violated the applicant's right to life under Article 4 of the Charter in relation to the mandatory imposition of the death penalty. Holds that the respondent state violated the applicant's right to dignity and the right not to be subjected to cruel, inhuman, or degrading punishment and treatment protected under Article 5 of the Charter in relation to the imposition of the death penalty by hanging. On reparations, dismisses the applicant's prayers for reparations. Orders the respondent state to revoke the death sentence imposed on the applicant and remove him from death row. Orders the respondent state to take all necessary measures to remove within 6 months of the notification of this judgment the mandatory death penalty from its laws. Orders the respondent state to take all necessary measures within 1 year of the notification of this judgment for the rehearing of the case on the sentencing of the applicant through a procedure that does not allow the mandatory imposition of the death sentence and upholds the discretion of the judicial officer. Orders the respondent state to take all necessary measures within 6 months of the notification of this judgment to remove hanging from its laws as the method of execution of the death sentence. Orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the judiciary and the Ministry for Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. orders the respondent state to submit to it within 6 months from the date of notification of this judgment, a report on the status of execution of the orders set forth herein and thereafter every 6 months until the court considers that there has been full implementation thereof. On costs, unanimously orders that each party shall bear its own cost. In accordance with Article 28.7 of the Protocol and Rule 73 of the Rules, the declarations of Judge Rafa Ben Ashur, Judge Blaise Chikaya, and of Judge Dumisa bin Sebeza are appended to this judgment. Done at Arusha, this 26th day of June in the year 2025 in English and French, the English text being authoritative. I thank you, Mr. President.
Telle est la décision de la Cour. Requête numéro
Judgment of the
013-2018.
court.
Emmanuel Yusufu.
Application number 013-2018, Emmanuel Yusuf Noriega versus the United Republic of Tanzania. The registrar is Emmanuel and his lawyers here,
Thank you, Mr. President.
as well as
The
the
representatives
representatives
of
of the
both parties
responses.
are in the hall. Thank you.
Très bien. La décision sera lue par l'honorable juge
This
Duncan Gaswaga.
judgment will be read by Honorable Judge Duncan Gaswaga.
Thank you, Mr. President. In the matter of Emmanuel Yusufu Noriega versus United Republic of Tanzania, application number 013 of 2018, judgment done on this day. The court composed of Modibo Sako, President, Chafika Ben Saula, Vice President, Rafa Ben Ashu, Susan Mengi, Tujilani R. Chizumire, Blaise Chikaya, Stella I. Anukam, Dumisa Bin Sebeza, Dennis D. Ajaye, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 9, Sub-Rule 2 of the Rules of the Court, Justice Iman D. Abudi, Judge of the Court and the Nation of Tanzania, did not hear this application. Subject of the application, facts. It emerges from the record that the applicant murdered Ismail Omari Kangwa, whom he suspected of practicing witchcraft and for allegedly killing his father on 3rd November 1995 at Ilagala village, Igoma. In the proceedings before domestic courts, the applicant alleged that he was intoxicated and under the influence of drugs, having smoked bangi, when he attacked the deceased and severed his head from his body. The applicant was arrested for murder by the police on the 4th of November 1995, tried, convicted, and sentenced to death on 18th March 2005 by the High Court of Tanzania sitting at Tabora in criminal case number 34 of 1997. Dissatisfied with the decision of the High Court, the applicant appealed to the Court of Appeal of Tanzania sitting at Dar es Salaam in criminal appeal number 152 of 2005, which dismissed the appeal in its entirety for lack of merit on the 27th of October 2009. The applicant then applied to the Court of Appeal for a review of its judgment in criminal appeal number 9 of 2014, which was dismissed for lack of merit on the 18th of August 2017. Prayers of the parties. The applicant prays the court to 1, declare the application admissible and grant his request for provisional measures. 2, dismiss the respondent's preliminary objections. 3, grant him free legal aid. 4, order the restoration of his rights. 5, order for reparations should the court establish a violation. 6, release him from prison. 7, refrain from executing the death penalty against him pending the determination of his application. And 8, order the respondent state to report on the measures taken to implement its orders. On the other hand, the respondent state prays the court to 1, declare that the court is not vested with jurisdiction to adjudicate the application. 2, declare that the application is inadmissible. 3, dismiss the application. 4, declare that the respondent state has not violated the applicant's rights under Articles 3.1, 2, 5, and 7.1a, c, and d of the Charter. 5, dismiss the application with costs. And finally, 6, make any other orders that the court deems fit. The operative part of this judgment. For the reasons already cited in the judgment, the court unanimously on jurisdiction, 1, dismisses the objection to its material jurisdiction. 2, declares that it has jurisdiction. On admissibility, 3, declares that the application is admissible. On merits, 4, the court holds the respondent state holds that the respondent state did not violate the applicant's rights to equality and equal protection of the law as guaranteed under Article 3 of the Charter. Holds the respondent state did not violate the applicant's rights to a fair trial regarding the failure of the court assessors to examine the witnesses as guaranteed under Article 7.1 of the Charter. Holds that the respondent state violated the right to dignity and not to be subjected to cruel, inhuman, or degrading punishment and treatment guaranteed under Article 5 of the Charter in relation to its agent, the justice of the peace's failure to order prompt investigations or police brutalization. Holds that the respondent state violated the applicant's right to a fair trial by failing to provide the applicant with effective free legal assistance as guaranteed under Article 7, Subarticle 1c of the Charter, as well together with Article 14, 3d of the AfCHPR. By a majority of 7 judges for and 3 judges against, Justices Chafika Ben-Saula, Stella I. Anukam, and Dennis D. Ajaye, partially dissenting. 8, holds that the respondent state has violated the applicant's right to a fair trial by failing to try him within a reasonable time as guaranteed under Article 7, Subarticle 1d of the Charter. By a majority of 8 judges for and 2 judges against, Justices Blaise Chikaya and Dennis B. and Dumisa B. Nsebeza dissenting. 9, holds that the respondent state violated the applicant's right to life protected under Article 4 of the Charter in relation to the mandatory imposition of the death penalty by failing to allow the judicial officer's discretion to take into account the nature of offense and the circumstances of the offender. 10, the court holds that the respondent state violated the right to dignity and not to be subjected to cruel, inhuman, or degrading punishment and treatment guaranteed under Article 5 of the Charter in relation to the imposition of the death penalty by hanging. Unanimously, on reparations, starting with pecuniary reparations, 11, grants the applicant's prayer for reparations in respect of the moral prejudice as a result of the violation established and awards him the sum of Tanzanian shillings 1 million. 12, orders the respondent state to pay the sum awarded in 9, above, free from tax, as fair compensation within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the amount is fully paid. On non-pecuniary reparations, 13, does not grant the applicant's prayer for release. 14, the court orders the respondent state to revoke the death sentence imposed on the applicant and to remove him from death row. 15, orders the respondent state to take all necessary measures within 6 months from the notification of this judgment to remove the mandatory imposition of the death penalty from its laws. 16, orders the respondent state to take all necessary measures within 6 months from the notification of this judgment to remove hanging from its laws as a method of execution of the death penalty. 17, orders the respondent state to take all necessary measures within 1 year of the notification of this judgment for the rehearing of the case on the sentencing of the applicant through a procedure that does not allow the mandatory imposition of the death sentence and upholds the discretion of the judicial officer. 18, orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the website of the judiciary and the Ministry for Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. On costs, the court orders each party to bear its own costs. Signed by Modibo Sako, President, Shafika Bensaoula, Vice President, Rafa Benahou, Susan Menge, Tujirani R. Chizumile, Blaise Chikaya, Stella Aya Nukam, Dumisa Bin Sebeza, Dennis D. Ajaye, Duncan Gaswaga, judges, and Robert Eno, registrar, in accordance with Article 28, Sub-Article 7 of the Protocol, and Rule 70, Sub-Rule 3 of the Rules. The separate opinion of Justice Rafa Benahou, the partially joint dissenting opinion of Justices Shafika Bensaoula, Stella Aya Nukam, and Dennis D. Ajaye, and the declarations of Justices Blaise Chikaya and Dumisa B. Nsebeza are appended to this judgment. Done at Arusha this 26th day of June in the year 2025 in English and French, the English text being authoritative. Thank you, Mr. President.
Telle est la décision de la Cour.
This is the decision of the court.
Requête numéro 014-2018.
Application number 014 of 2018.
Ajaye,
Jogoo versus United Republic of Tanzania. The councils of the parties represented here. Thank you. Honorable Judge Stella I. Anukam is going to read this judgment. Honorable Stella, you have the floor. Thank you, Mr. President.
I read the ruling in the matter of Ajaye Jogoo versus the United Republic of Tanzania, application number 014/2018. And the ruling is dated today, the 26th day of June, 2025. The court, composed of Modibo Sako, President, Shafika Bensaoula, Vice President, Rafa Benahou, Susan Menge, Tujilani R. Chizumila, Blaise Chikaya, Stella I. Anukam, Dumisa B. Nsebisa, Dennis D. Ajaye, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9 sub 2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani D. Aboud, member of the court, and the National of Tanzania did not hear this application. After deliberation on this matter, the court renders his ruling as follows. The subject matter of the application. I begin with the facts of the matter. The applicant alleges that on the basis of a memorandum of understanding between the Republic of Mauritius and the Revolutionary Government of Zanzibar, signed in 1999, the Minister of Economic Planning of Zanzibar made a public expression of interest, inviting Mauritanian companies to invest in Zanzibar. In that regard, the applicant under his company, Commerzbank Limited, signed a concession contract with the government of Zanzibar in a joint venture for the construction of Yamazi Free Zone Park. On the 21st of September 2001, however, the government of Zanzibar revoked the concession contract, citing the inability of the applicant to secure funding to the tune of United States dollars 150 million for the joint venture. The applicant alleges that following the revocation of the concession contract, he was, on the 26th of September 2001, unlawfully deported to the Republic of Kenya. The applicant alleges that he traveled back to Zanzibar from Kenya and he was arrested once again on the ground that he was an illegal immigrant. He further alleges that his passport was stamped with a prohibited immigrant label, number 00000455. The applicant further avers that he was arraigned before the Wankwarangwa District Court on the 22nd of January 2002, and that the hearing of the case was conducted in Swahili, a language that he does not understand. He alleges that on the 4th of February 2002, the Wanakwarangwe District Court ordered that the applicant be released on bail for 3 months, following which he should be deported to the Republic of Mauritius. The applicant avers that he was thus deported to the Republic of Mauritius at the end of a 3-month period. On the 25th of August 2004, the applicant wrote a letter to the respondent state requesting it to waive the prohibited immigrant status on his passport and that he be allowed to enter the respondent state so as to recover his personal assets. On the 15th of October 2004, the Ministry of Investment and Planning of the Revolutionary Government of Zanzibar informed the applicant that his prohibited immigrant status would not be waived, but rather he should appoint an advocate who would go to Zanzibar and ascertain his property and dispose of them if necessary. Unable to return to the respondent state, the applicant filed a case in 2009 before the Southern Africa Development Tribunal, the SADC Tribunal, to challenge the deportation order and further allege that he had been tortured and ill-treated during his detention in Tanzania. In the matter before the SADC Tribunal, the respondent state raised 3 preliminary objections, including the applicant's failure to exhaust local remedies. On the 11th of June 2010, the SADC Tribunal dismissed the applicant's case for failure to exhaust local remedies. The applicant claims that he did not receive any more correspondence from the respondent state until 2017, when he sent a request to the respondent state consulate in the Republic of Mauritius and the Republic of Mauritius Consul in Tanzania. In his request, he requested the Ministry of Home Affairs to remove his prohibited immigrant status on his passport. The applicant further alleges that at the time of filing the present application before this court, 17 years had lapsed while his rights were continually being denied. The alleged violation. The applicant alleges violation of the following rights. One, the right to non-discrimination protected under Article 2 of the Charter. The right to equality before the law and equal protection of the law protected under Article 3 of the Charter. The right to a fair trial as protected under Article 7 of the Charter and Article 14 of the International Covenant on Civil and Political Rights. The right to receive information protected under Articles 9 sub 1 of the Charter and Article 19 of the AfCHPR. The right to physical and mental health protected under Article 18 of the Charter and Article 12 of the International Covenant on Economic, Social, and Cultural Rights. And lastly, the right to property protected under Article 14 of the Charter. The prayers of the parties. The applicant prays the court for number one, a declaration that the application meets the admissibility requirements. Two, a declaration that the respondent state violated its right to fair trial. And three, a declaration that the respondent state is causing an inordinate delay in his case. The respondent state did not participate in the present proceedings and therefore did not make any prayer. In the instant case, the applicant did not submit any evidence of assertion of local remedies, but he presented two arguments. First, he argues that there was a case pending against him that was unduly prolonged. And second, he affirms that his prohibited immigrant status was an impediment that he would not surmount in order to exhaust local remedies. The court observed that between the 1st of February 2002 and the 5th of June 2002, a period of 4 months elapsed during which the applicant, who was on bail, could and should have appealed the decision of the district court, granting him bail for 3 months and confirming his deportation. Nevertheless, the applicant did not provide reasons as to why he did not challenge his deportation order while he was on bail. In addition, as regards his prohibited immigrant status, making it impossible for the applicant to seize the courts of the respondent state, the applicant does not demonstrate that he tried to file cases in the respondent state through a legal representative and was denied the same, and is therefore casting aspersions on the respondent state. In the light of the foregoing, the court finds that the applicant failed to exhaust local remedies, so that the application does not comply with Article 56(5) of the Charter as restated in Rules 52E of the Rules of Court. Having found that the application does not satisfy Rule 52E of the Rules, the court does not need to rule on the admissibility requirement set out in Article 56(6) and sub 7 of the Charter, as restated in Rules 50 sub 2F and G of the Rules, as the admissibility requirements are cumulative. In view of the foregoing, the court declares the application inadmissible. On cost, the applicant did not make any submission on cost. In the instant case, since there is no justification that warrants a departure from Rule 32 sub 2 of the Rules, accordingly, the court holds that each party shall bear its own cost. I now read the operative part of this judgment. For these reasons, the court unanimously and in default rules as follows. On jurisdiction, declares that it has jurisdiction. On admissibility, declares the application inadmissible. On cost, orders each party to bear his own cost. This ruling is signed by the bench as earlier mentioned, including the registrar, Dr. Robert Eno, and is done this day at Arusha, this 26th day of June in the year 2025 in English and French, the English text being the authoritative text. Merci, Monsieur le Président.
Telle est la décision
de la Cour.
is the judgment of the court. Application number 009 of 2019, Bahati Tega versus United Republic of Tanzania. That the registrar, the applicant's counsel represented here. Very well. This ruling will be read by Honorable Judge Duncan Gaswaga.
Thank you, Honorable President. In the matter of Bahati Tega and Flowing Mtreve versus United Republic of Tanzania, application number 009 of 2019, judgment issued today. The court composed of Modibo Seckou, President, Chafika Bensaula, Vice President, Rafa Benashu, Susan Menge, Tujilani R. Chizumira, Blaise Chikaya, Stella I. Anukam, Dumisa Bin Sebeza, Dennis D. Ajaye, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, and Rule 9, Sub-Rule 2 of the Rules of the Court, Justice Iman D. Abud, a member of the court and the Nation of Tanzania, did not hear this application. The facts of the matter. It emerges from the record that the applicants were arrested on the 26th of October 2010, having been accused of raping one Esther Chilo, a resident of Lipangala village in Ludewa district. They were taken to Lugarawa police station, where they were charged with the offense of gang rape. The applicants were subsequently arraigned before the District Court of Ludewa. On 2nd September 2013, after full trial, the District Court convicted them of gang rape and sentenced them to life imprisonment and 12 strokes of the cane each. On 14th February 2014, the applicants appealed to the High Court of Tanzania, sitting at Iringa, seeking to quash both their conviction and sentence. On 18th September 2015, the High Court upheld the judgment of the District Court and dismissed the applicant's appeal. The applicants then filed an appeal against the High Court's judgment before the Court of Appeal of Tanzania, sitting at Iringa. On 3rd August 2016, the Court of Appeal dismissed the applicant's appeal. Prayers of the parties. The applicants pray the court to find that the respondent state has violated the following rights. 1, the right to enjoyment of rights and freedoms in the Charter without distinction under Article 2 of the Charter. 2, the right to equality before the law and to equal protection of the law under Article 3 of the Charter. 3, the right to dignity under Article 5 of the Charter, and 5 and 4, the right to a fair trial under Article 7 of the Charter. The applicants also pray the court to grant the following remedies and reparations. 1, the setting aside of the sentence of life imprisonment in jail and of 12 strokes of the cane imposed on the applicants. 2, restitution of the applicants' liberty by their release from prison. 3, payment of reparations in the amount of 100 million Tanzanian shillings for each on account of moral damage suffered, to compensate the applicants for the loss in their dignity and reputation, as well as physical, mental, and emotional harm. 4, rehabilitation of the applicant Bahati Tega, who is HIV positive, in order to receive proper medical and psychological care. 5, the applicants also pray that the respondent is ordered to amend its laws to ensure respect for dignity as enshrined under Article 5 of the African Charter on Human and People's Rights by removing the corporal punishment in her statute books. On jurisdiction and admissibility, the respondent state prays the court to order that 1, the African Court on Human and People's Rights is not vested with jurisdiction to adjudicate the application. 2, that the application had not met the admissibility requirements provided by Rule 40, Sub-Rule 5 of the Rules of the Court. 3, the application be declared inadmissible. And 4, the application be dismissed. On the merits, the respondent state prays the court to grant the following orders. One, that the respondent has not violated any of the applicant's rights provided under Article 5 of the African Charter on Human and People's Rights. Two, that the respondent has not violated any of the applicant's rights provided for under the African Charter on Human and People's Rights. Three, that the respondent has not violated Article 12, Sub-Article 1 and 2 of the Constitution of the United Republic of Tanzania, 1977, as amended from time to time. The operative part of the judgment, for the reasons as already discussed in the judgment, the court unanimously on jurisdiction, one, declares that it has jurisdiction. On admissibility, two, dismisses the objection to the admissibility of the application. Three, declares the application admissible. On merits, the court holds that the respondent state did not violate the applicant's right to non-discrimination as provided for in Article 2 of the Charter. 5 holds that the respondent state did not violate the applicant's right to equality and equal protection before the law as provided for in Article 3 of the Charter. 6, the court holds that the respondent state violated the applicant's right to dignity as provided in Article 5 of the Charter by maintaining corporal punishment in its criminal laws. 7, the court holds that the respondent state violated the applicant's right to a fair trial as provided in Article 7, Sub-Article 1C of the Charter by failing to provide them with free legal assistance in domestic proceedings. On reparations, on pecuniary reparations passed, 8, the court does not make any award for material prejudice. 9, the court grants the applicant's prayer for damages for moral prejudice and awards each of the applicants the sum of 300,000 T shillings as compensation. 10, orders the respondent state to pay the sum awarded under 9 above, free from tax, as fair compensation to be made within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the amount is fully paid. On non-pecuniary reparations, 11, the court dismisses the applicant's prayer for the quashing of their conviction and release from prison. 12, orders the respondent state to set aside the sentence of 12 strokes of the cane imposed on the applicants. 13, the court orders the respondent state to take all practical steps to ensure that its criminal laws are aligned with its human rights obligation by expunging corporal punishment from its laws within 1 year from the date of notification of this judgment. On implementation and reporting, the court orders the respondent state to submit to it within 6 months from the date of notification of this judgment a report on the status of implementation of the decision set forth herein, and thereafter, every 6 months until the court considers that there has been full implementation thereof. On costs, the court orders that each party shall bear its own costs. Signed by Modibo Sako, President, Shafika Bensaoula, Vice President, Rafa Benashu, Judge, Susan Menge, Tujiran R. Chizumire, Blaise T. Chikaya, Stella Ayanukam, Dumisa B. Seveza, NCD Ajaye, Duncan Gaswaga, Judges, and Robert Eno, Registrar. In accordance with Article 28, Sub-Article 7 of the Protocol and Rule 70, Sub-Rule 1 of the rules, the separate opinion of Justice Blaise Chikaya is appended to this judgment. Done at Arusha, this 26th day of June in the year 2025, in English and French, the English text being authoritative. Thank you, Honorable President.
Merci, juge Kassoga.
Judge Gassaga.
Les affaires inscrites auront aujourd'hui pour être
The matters for today have been exhausted.
Lu par l'honorable juge Gassoga.
Judgment read by Honorable Judge Gassaga is read on behalf of the court. I said that all the judgments for today have been read, and with this, the court rises.
Hello, Jack. Yes, I'm speaking to English now. Jack. You hear me now? Jack, can you hear me? He didn't see you here. Are you down in the Kibo Hall or where? Hello, Jack. Jack, are you here?